Good evening, ladies and gentlemen, distinguished guests, respected panelists, friends, and colleagues. A very warm welcome to the India International Center and to the launch of Unshackling the Elephant by Anand Prasad, a book that promises to do exactly what many of us have secretly wished during long queues, even longer forms, and the occasional brush with our beloved legal system. Help unshackle it all, thoughtfully and insightfully. Thank you all for being here this evening and for taking out the time on a Sunday, a day that is usually reserved for reflection or the quiet denial that Monday is around the corner. Before we formally begin, a quick note on the flow of the evening. We will start with a brief opening remarks and introductions, followed by an overview of the book and the author. We will then move into a panel discussion, open the floor briefly for audience questions, and conclude with closing remarks, after which you're most welcome to join us for drinks and dinner in the Annexy courtyard. Ladies and gentlemen, I will now invite our guest of honor, followed by our moderators and panelists, to kindly join us on stage. May I request the Sunflower team to assist and escort our speakers, our guest of honor, Justice A.K. Patnaik, our panelists, Justice Siddharth Mridul, Niranjan Reddy, Rahul Ahluwalia, and of course, Anand Prasad, and our moderators, Shweta Rajpal Kohli and Apurva Mandhani. Justice A.K. Patnaik, former judge of the Supreme Court of India, where he served from 17 November 2009 until his retirement on 2nd June 2014. The first time he was elevated as an additional judge of the Orissa High Court was on 13 January 1994 and subsequently transferred to the Guwahati High Court as an additional judge on 7th February 1994. He was made a permanent judge of the Guwahati High Court in 1995. Prior to being the judge of the Supreme Court of India, he was the Chief Justice of Madhya Pradesh High Court from 2005 to 2009 and Chhattisgarh High Court from March 2005 to October 2005. After retirement, he's been doing chamber practice, including arbitrations. Justice Patnaik has contributed immensely to India's legal landscape, and we are honored to have him with us today. His presence here today lends great gravitas to this evening and to the ideas explored in Unshackling the Elephant. So may I please request you to share a few words with us.
Good evening to all of you. You just heard that I have been a judge in different high courts, starting from Guwahati, Orissa, then Chief Justice of Chhattisgarh, then Madhya Pradesh, then Supreme Court. And I have experienced the judicial system. And while as a Chief Justice of Madhya Pradesh, I tried to do a lot of things to improve the justice delivery system.
Check.
Criminal cases are disposed of fast in the trial court. Civil cases are disposed of fast in the trial court, and I did succeed. Civil suits, what I did was increase the number of judges in the subordinate judiciary. And wherever there were excess judges in whichever district, I pulled them out and put them in the right places where they were needed. The result was the system improved. So much so that the suits were being disposed of in 1 year time. Sessions trials were being over from the date of charge sheet in 6 months' time. So while the bail matter was pending in the High Court, the trial was over. While a temporary injunction matter was pending in the High Court, the suit was over. This was the situation in the Madhya Pradesh High Court. But then when I left, when I came to Supreme Court, I found all those had piled up in appeals before the High Court. The High Court is jammed. And strength of High Court judges had not been increased. So, when I read this book, I find a lot of truth in what he's saying. You reform in one side, and problems start on the other side. So criminal appeals got vertical disposed of very late. They are all jammed. So this book, when I read, Mr. Anand Prasad has rightly titled it Unshackling the Elephant. Judicial system in India is really an elephant. It has to be unshackled. And he has raised these issues. Slow decay of the rule of law. You see that? Slowly taking place. I wonder whether you have read a book by Anita Gets Bail by the former Minister, Union Minister, Arun Shourie. Read that book. He has given description what in our courtroom discussion. So, slow decay in the rule of law. Compliance with the law and the rules have become very costly. We are noticing that. And where rightly mentioned is, so compliance with the law, if it has become very costly, it is easier and cheaper to circumvent the law. Therefore, no compliance. So people prefer to do that. No respect for contract. They commit breach and the relief is delayed. These days there are arbitration cases. In arbitration also, I have been doing arbitration for the last, since I have retired. I deliver my awards very fast. And therefore I get a lot of cases. But they all get stuck up in section 34 before the High Court and thereafter the appeals. So relief is very related. Then no respect for laws, as far as criminal law is concerned. And culprits go unpunished. He has mentioned 10% convictions only in criminal courts. Right. And that is very much correct, but I must tell you, in Madhya Pradesh, when I was there, convictions are around 60%, 70%. Right. In different trial courts. And bail, he has mentioned, not easily granted. This is the worst thing that's happened to our system. He rightly mentioned. He said bail is the rule, but now bail has become the exception. And trial itself, going through the trial and then ultimately being acquitted is a punishment. You all remember that famous case in Noida, that couple, Talwar case. I was in the Supreme Court when the matter came before me, after one of the judges retired, came for review. I said, why, when the CBI has given a closure report, why it has been opened up again with the trial court? And he summoned that was the challenge. When I was going through, I found a lot of gaps. And this was not a case where it would ended up in a conviction. Nevertheless, the law was, at that stage, summons can be issued when the magistrate, if there are some materials, the court cannot go into that question. So we rejected the petition, but we granted bail. Eventually what happened? The High Court accepted. Why they had to go through all that? Punishment, embarrassment, harassment, bad name in the media. Then he has also mentioned when the Constitution was made, the thought of we'll be bringing about, if you look at the preamble of the Constitution, socio-economic justice, all high-sounding words, almost like Ram Rajya, refer to Ram Rajya. What was promised to people is a Ram Rajya. Instead, There's failure to rule of law, deliver rule of law. This is the position. And then he says, people have become materialistic and want to accumulate wealth and have given up their traditional values. They become dishonest and greedy. A lot of problems are rising because of this character deterioration in our society. And when it comes to legal reforms, politicians or political rulers don't make that as a manifesto, election manifesto. They are not concerned with that. They'll rather pay some money to the people directly, 10,000 rupees or this, you know that, per month or something. It is not an important issue in election. Why? Because most of the common men are concerned with food, clothing, nutrition, medical facilities, shelter. They are not concerned with the rule of law. A very, very important thing that is mentioned. So who is going to take up the rule of law? That's what he's saying. But nevertheless, he has suggested some legal reforms. And some of the legal reforms I laid out, but rest I will not, because you must read the book to understand what effort he has made. Some of the reforms that he has suggested are, reform should not focus only on new substantive law. It should rather focus on speedy implementation of the laws. That is what is mentioned. And I entirely agree with you. They make laws after laws, without making what they call an assessment of a new law on the present system of judiciary. There is no impact assessment. The result is the courts are burdened with new laws and they cannot implement whatever laws were there for. Then more of professionalism says in justice delivery system and a more common sense approach to the law. And he has suggested a very good idea to build a centralized knowledge of grid for lawyers and judges, which can be accessed by them so that there can be informed and consistent decisions. Very nice. In fact, the present CGI is already talking about certainty of law. There is no certainty of law. There is no certainty of law in the country. And when it comes to Supreme Court, most uncertain. It all depends on which bench it goes. One bench will take one view, another bench will take another view, third bench will third view. You never know what will happen to the SLP or the civil appeal. Uncertainty of laws to that extent. So this is a good assessment how it can be brought about. One has to see certainty of law. Then he has said that templated pleadings with the help of AI so that all litigants are placed equally irrespective of the caliber of lawyers. With a lawyer like Mr. Reddy sitting on one side and another lawyer who is not that capable as Mr. Reddy, the other side has got a tough time. He does not have equality before law. So he wants to ensure that all this pleading, everything is, standardized. And you go to the AI and give. And I find that the AI has a lot of things fed into it. My grandson asked me a question that we have a judiciary, we have some essay writing. Now, please tell me these. He put some queries to me. How can the judicial system, how can the delays be avoided, how can things changes? Then immediately for me, when I started saying, he was looking at his laptop. Whatever I was saying, it is there already. In the AI has said this has to be done, alternate dispute resolution, speed, everything. Everything is provided. So they are all fed down. Then he has suggested, Mr. Prasad has suggested, recording and broadcasting of proceedings to enhance transparency and accountability. That's very, very important. It's already happening. Now Supreme Court proceedings are being, you can watch it. That's a very good sign. Very good sign. And I remember when I was in Supreme Court, this was not there. And some of our judges also were unrestrained. They used to make a comment, any comment. Now it is not possible. I remember I was sitting with a particular judge. He made a comment on a very senior lawyer. And the senior said that, I will not appear any longer in this court. Then I just told the senior lawyer, calm down, calm down, calm down. So judges are also prone to, if you incite them, they'll come out. They'll be provoked, they'll say something. He said, why? We are not granting bail. We said, we are not granting anticipated bail. Then he said, all right. Then let a direction be given within 6 months. The trial should be over. So my brother judge said, why? Is it because you senior lawyer so-and-so is saying so? The system should be uniform. Why you should have preference? He got irritated. Right. So these comments will not come out. And in any case, you find one comment made by Chief Justice or a judge out in the papers. So transparent. Reactions. Lawyers signing. This statement should not have been given. Another set of lawyers saying, no, there is nothing wrong in that statement. You have seen the papers. So therefore, judges should be restrained. They should not express this opinion. Listen, discuss, and pass an order. Transparency will help that. Lawyers should not resort to lying and perjury. Very difficult, very ambitious. Right. Very, very ambitious goal. And should not extract high fees. This is again very ambitious. They can charge, this is a good session again, they can charge contingency fees after winning a case and take only a small fee at the beginning. It's quite a sensible thing. Very recently, I found my son, he hardly charged any case fees. And the claim was big, the insurance claim. And when the party succeeded in the Supreme Court, the party said, sir, I have got 13 crores now. I didn't expect this. I'll give you a big chunk. Don't ask me what is that big chunk. But it did, right? So this is very successful. These can work very nicely. Then he said, we must follow the American system of consequential damages, penal damages, and award costs to the winning party as per actuals. This will stop the unnecessary claims, you know that. This is a very, very important idea, and there is also a book written by costs by Arun Mohan.
Dr. Arun Mohan.
Dr. Arun Mohan. Very nice book. This awarding of costs is very important. Then corporate fraudsters, he has named them Nirav Modi and Vijay Mallya. Right.
I can represent you when you get sued.
They should end up becoming poor. There are, he has excluded some also, some more. Yeah, right. Anyway, I am not saying so, he has said so. Whistleblowers should be rewarded and witnesses must be protected. It's very much true. Witnesses should be protected, whistleblowers should be rewarded. But all these provisions have come in now. Witness protection has come in. Not implemented. Nothing. Now, courts should be inquisitorial like the European courts, not adversarial like the US and English courts. This will be in alignment with the Indian mindset. He's right. This is very important. We find that truth doesn't come out unless if the parties are not pleading anything, you can't go, court cannot go on its own and try to get to the truth. This is what he says. Court should be allowed to go through own. And we find in arbitration also. Sometimes my colleague says, we can give this. I said, the arbitration, he must claim. No? The law is also made like that. He has not made a claim, how will he give it? Now, and then it says, we must discard the concept of sovereign immunity. This is very much correct. To some extent, civil law, sovereign immunity, Supreme Court had set it right. And awarded damages also against the state. And for wrongful prosecution also, there is a provision of wrongful prosecution is there. Malicious and wrongful prosecution. There are provisions there, but they are not resorted to. Some people should dare do it. Then only the system will come. But this is a good session. Now, to be deterrent, he says punishment that we impose on the CRPC when I was there. Now the law has changed, some new name given. The punishment should be cumulative. Say three offences. 5 years for this offence, 5 years for this offence. So he should suffer 15 years. What we do today, the law was concurrent. So the punishment is less. He says more this cumulative effect is given, then it become deterrent, more deterrent. Then police should be prosecuted if they have been found to have used illegal force during investigation. This is very, very important. Police do a lot of things unpunished. This is very, very important session. If police has to be made accountable, this is very, very important. Police is not at all accountable in our country. And then this again, this is a good session. Some restrictions on lawyers have to be removed, such as lawyers cannot have a website. We cannot advertise. And lawyers cannot have businessmen as partners. Some restrictions. But I find when I see the WhatsApp and all that, libel law, everything, many of the lawyers are already advertising. You notice that many of, particularly youngsters, are very much advertising, and those who are very value-based lawyers, conservative type, they don't like advertising. But many of the youngsters, they don't know about those restrictions, they keep on advertising. So these are the suggestions he made. And he has written number of chapters which I have not gone through details, but I can give you the headlines. Chapter 2 is advancing courtroom technology. This I entirely agree with him. One must go through technology, and he has got good experience, having worked in trilegal for quite some time. Must have done a number of international arbitrations, gone abroad and all that. I was doing a number of international arbitration. I find how they have advanced by technology. Then, revamping India's commercial legal system. Commercial legal system is very slow. In fact, India, there is no commercial legal system at all. When you do arbitration cases on minimum principles of contract, there is no case law. There is no case law of the Supreme Court. We rely on Commonwealth law, English law, American law, even law in Singapore. But India, there is hardly any case law. Right? We find it very difficult. And sometimes there is case law. I was sitting with Justice Jagannath Rao. Studies a lot. And then he said something in the courtroom, in the arbitration, he was preparing after. I said, sir, this is contrary to what the Supreme Court has laid down. Which case? Then I showed him the case. He said, we must overrule the Supreme Court. And this happens because the Supreme Court itself, judges don't know. And India is a peculiar system. Judges who have never done arbitrations, they're sitting in commercial courts or in the Delhi High Court or in the Supreme Court, never done arbitration. They start doing arbitration after retirement from a High Court or the Supreme Court. Then only they come to know what is arbitration. But they set aside our awards. One very good principles, no doubt about it. But experience is also required in the field to be able to judge. Then fourth, he said, harmonizing Indian law with Indian sense of justice. This is very important. You see the criticism going on Macaulay. Now, Macaulay, there is no criminal law, no Indian penal, no penal, English penal code there. But Macaulay introduced the Indian penal code here on the basis of English principles of common law. And mind you, झगड़ा तो होता रहता है, फिर भी झगड़ा होता है. In the agriculture field too, agricultural laborers fight. He accuses something, your wife is so and so. So he said, yeah, you are making allegation of my wife. He picks up an axe and gives one blow. The other fellow is dead. Murder ho gaya. She is an Indian, he is maybe a tribal, maybe a Dalit, maybe someone. He is provoked by emotions, he kills, and look at the punishment. This is typical English law, implemented in India. Then he has also said for constitutional reforms. He is very tall order. Constitutional reforms. For a lawyer to write constitutional reforms. You know what type of constitutional reforms now being introduced by Parliament? Something which must have a political consequence. Political consequence, there is no question of constitutional reform. So many constitutional reforms are required. But the constitutional reforms are possible only if, first of all, there is no law with regard to political parties. No constitutional provision. No constitutional provision how political parties will be funded. I am writing all those materials. But I am confident that लिखे हुए तो कोई सुनेगा नहीं. Because it will be contrary to their interest. Anyway, very ambitious. And then finally said redefining boundaries, fine-tuning of legal principles. I have not gone through it. There may be very good suggestions there. I hope people read this book. And I sincerely feel that he should be in the Law Commission of India. If some voice. Oh, Law Commission in India also, whatever they recommend, it's not ultimate, it's all political. Thank you very much.
Thank you so much, sir, for sharing your experiences and for those insightful words. Joining him, we have our session moderators, Shweta Rajpal Kohli and Apurva Mandani. Shweta Rajpal Kohli today is the President and CEO of Startup Policy Forum, a major industry body and advocacy group representing India's leading new age companies like Cred, Swiggy, Razorpay to shape favorable policies, foster innovation, build community, and promote India's startup ecosystem globally, bridging founders with policymakers and investors to boost India's digital economy. We also have Apurva Mandani, who's a senior assistant editor at The Print, an award-winning journalist. She covers politics and the judiciary. She's a law graduate from the Symbiosis Law School, Pune. She's an experienced legal and policy content creator and editor, having written over 1,500 articles for various websites such as Life Law, SSCO Online, etc., and the like, having been republished by websites like The Wire since 2014. We are also joined by our esteemed panelist, Justice Siddharth Mridul, former Chief Justice of the Manipur High Court. Justice Siddharth Mridul was first elevated as an additional judge of the Delhi High Court on March 13, 2008, and then appointed a permanent judge on May 26, 2009, serving there for over 15 years before becoming the Chief Justice of the Manipur High Court in October 2023. After retirement, he's been practicing law as a senior counsel in the Supreme Court. Niranjan Reddy, Member of Parliament, Rajya Sabha, is a senior advocate and is also designated at the Hyderabad High Court. He is also a member of the Parliament and Standing Committee for Information Technology and may have a role in shaping the way technology will influence the lives of the citizens of India. He was also a deputy chairperson of Rajya Sabha for a brief period. And Rahul Ahluwalia is currently the founding director for the Foundation for Economic Development. He has previously worked for Bill and Melinda Gates Foundation and Niti Aayog, where he contributed to policy documents on governance, education, poverty measurement, and water resources. He has an MBA from IIM Calcutta and a master's in economics from the University of British Columbia. He also runs a popular YouTube channel on policy and economics, which goes by the name The Convergence Foundation. And of course, Anand Prasad, author of Unshackling the Elephant, and a distinguished legal professional whose work continues to engage deeply with India's institutional framework. Ladies and gentlemen, please join me in giving all our speakers and panelists and moderators a warm round of applause. May I also kindly ask all of you to keep your phones on silent during the session. To set the context for the evening and to give us an overview of the book and the author, I now invite Moksh, Managing Partner, APN Partners, to share a few words.
Thank you all for making it distinguished guests and ladies and gentlemen. It's my pleasure to welcome all of you today to this evening. I'm going to keep it brief because we've already had a fairly detailed and clear explanation to what the book says. In terms of, I'm going to start maybe with a few words about the author and then go into the book itself. Lawyers are very fond of legal maxims and aphorisms. For Anand, also as a professional, one is very apt, which is the thing speaks for itself. As a legal professional, he's had a storied career. First, as a founder of as a co-founder of Trilegal, and then as a co-founder of APN Partners, where we continue our journey today. That in itself would be enough of an introduction, but there are some things that get left out, which I would like to focus on, which is the nature of Anand as a legal thinker, and really why is he the right person to be thinking about these issues. There are two hallmarks of Anand as a thinker, which I think are very important here. One is the ability to be relentless in the pursuit of reason and truth. Whenever you're working with him, and there are many in this room who would attest to it, he would really be forceful in trying to get to an answer or an outcome for his client. In this case, the brief that he's holding is different. It's not a company, but it's more the common man. But he brings the same passion that he has for the practice of law to this question. The other is the ability, which I think is somewhat unique and interesting, is the ability to act without necessarily worrying about the sunk costs. It's very easy when you're working or thinking to work with certain assumptions because it makes life easy. Anand has the ability to sort of transcend that and look deeper and question further, which I think makes it very important, especially in this context, which is when you're looking to re-envision what the legal system should really look like. How is it that the common man should experience it? There is a third element, which is, I would suppose, more personal to him, but still very interesting, which is a distaste for the doctrinal and a preference to look at things in a more experiential way. And that brings us to the book. When you're reimagining or thinking about the legal system really, and you think, how does a ordinary person experience it? And then what are the solutions that are needed to make his life better, to make the law work for him? That is really the crux of what this book is about. This very basic and simple question of how do you make the legal system work for the common man takes us down some very interesting and important inquiries. What should be the relationship between the citizen and the state? How do you improve or build on judicial independence? What or how do you hold your officers accountable? How do you make sure that if somebody promises you something, that you can get that person to deliver on his promise? So those are very, very interesting questions that Anand has sort of looked to address in his book. He has made suggestions. You may not agree with all of them, but I think we will all agree that there is a need to ask these questions and have these discussions. With that, I think I will hand over to Farah, and I hope all of you enjoy the book as much as I have, and I hope you enjoy the discussion. Thank you.
Thank you so much, Moksh. We now move to the panel discussion, the heart of this evening, where our speakers will reflect on the themes raised in Unshackling the Elephant, explore their implications, and engage in conversation that spans law, governance, economics, and public policy. Without further ado, I hand the session over to our session moderators, Shweta Rajpal Kohli and Apurva Mandhani, to take the discussion forward.
Hello, everyone. As Farah mentioned at the start of this session, Sundays are for quiet reflection. I do hope we go back with a lot of reflection, if not quiet. For any of us who haven't read the book yet, I'll give a sneak peek, a very small one, with how the book begins. It begins with an illustration. There's a frog, smiling frog, in a pot which is labeled as a legal system. There's somebody saying this legal system feels warm and comforting, while the other person says that's not warmth, my friend, that's the litigation stove slowly boiling you alive. The frog, he says, is like an average Indian citizen. Anand, to begin with, we often talk about legal reforms while in law school. As a journalist, since I've been covering law in courts, how is your book different, and how we as frogs get out of this pot of boiling water? If you could, of course, Justice Patnaik has given us a really good overview of some of very ambitious reforms that you have suggested in the book. But as an author, how is your book different from all the other conversations?
Thanks, Apurva, for the question. So essentially, as most of us in this room and many of us are lawyers here would sort of know as a matter of fact, is that we look at the law on a daily basis when you go to court or when you advise a client. And your experience when you do that, a lot of it is theoretical in basis. Some of it is experience-oriented, or what happens in the real world. One of the things that we cross that line when you look at what happens in the real world is to deal with the shocking truth that a lot of what's written in the books may not actually play out. And then you start thinking in ways of what will work best for a client. And that's a daily encounter. We don't piece it together in that particular fashion in our heads. What this book suggests is that while you listen to policymakers and you listen to lawyers, they'll all sort of talk how the law is great and how we do a brilliant job in India and look at all solutions are there in law. Nobody tells you how long and how difficult and how tiresome it is to get there. And that is resulting in a loss of credibility in the legal system. So citizens are finding ways to sort of sidestep the legal system and find solutions outside the legal system. You will find that coming out in various different ways, whether it is using bribery, corruption, violence. There are various ways that people find to get what they believe is just for them. What this book is suggesting is if that keeps increasing in terms of percentage terms, and more of us start beginning to lose confidence in the legal system, it's like that frog that will ultimately boil to death. So unless a whole host of us jump up and start screaming, that slow, gradual increase in lawlessness will cause a collapse of a nation. So that's really why it suggests that we must do some fix.
Thank you so much, Anand. I'm going to take that forward, and Apurva started with the beginning of the book. Let me go right to the end of the book and talk about the reflection. And I want to throw it open to all the panelists, whoever would like to take it. I think Anand talks about a new order that is not defined by fear of authority, but by trust in justice. It's unlocking an India where opportunity is matched with fairness, where power is balanced by accountability, and where the everyday citizen finally stands at the center of nation's legal universe. My question to the panelists here, and anybody could take it up, is that if they could reflect from their journey of pain points or any anecdotes where they feel that the legal justice system of today is not adhering to the ideas that Anand has talked about in his closing remarks, and why some of these are absolutely essential as we're moving forward into an era which is defined so much more by tech and AI and everything around us changing at a pace that we had never thought before. So why should the justice system also feel the need to keep up and keep pace with that? Yeah.
That's an elaborate question. I'll try and break it up.
Sure.
First of all, what Anand mentions towards the end and I haven't got that far in the book, is a utopian concept.
That we switch from the common law system to the civil law system. First of all, it will need a constitutional amendment. He recognizes that.
I don't see that happening.
Second of all, the reason why he advocates the switch.
It will need a constitutional amendment. I'm retracing my steps. It's not going to be easy to go down that route, because whenever you change the constitution, and this is going to be changing the basic structure of the constitution, if I may use that expression, it will not happen. He does it because he believes that in an adversarial system which the common law supports, the judge cannot get to the bottom of a case. And I disagree with him. And I'll tell you why directly. Section 165 of the Evidence Act permits a judge, a trial court judge, to question every witness, every party, on every issue, whether it relates to a relevant fact or an irrelevant fact. The judge can question them. The judge can also seek production of all documents that may be there with a witness or with a party before the court. Now, why has this provision not been employed successfully or as widely as it should be? Which takes me to the basic difficulty that exists with our legal system. Our legal system is not prohibitive. We invite litigants to assert their rights by coming to court. We are very peculiarly situated. We have a large population. We have a colonial past, right? And we need our citizens to assert their rights before courts of law. But how have we gone about accomplishing that? Look at the judge population ratio. I know there are a lot of people who say that no, judges have a lot of holidays, therefore it's not the judge population ratio. But the judge population ratio is one of the principal factors. If you don't have a sufficient number of judges, and if you expect High Court judges to hear 200 matters a day, you surely cannot expect them to look at all the niceties of all the 200 matters listed before them. So this is one of the issues which I believe that Anand did not address, and I think he deliberately did not address this because there's already a lot of debate on this. And the executive and the judiciary have never agreed on this. Judges will always tell you we need more judges. The executive believes that there are enough judges as it is. They don't want any more. Because if there is any one pillar of state which questions the executive, it is the judiciary. You must bear that in mind. Therefore, the existence of the judiciary is not particularly relished by the executive. Because our principal purpose is to restrain the executive from conducting itself in a manner, both commission and omission, to discharge their executive functions. But I am digressing now. The question was something else. The question is that how do we get to that utopian state? I have no path which will definitely lead to that utopian state, but I can tell you this. If we were to implement our laws, and if the docket explosion was manageable, then we would have opportunity for judges. They would have the time to apply themselves to the task at hand, and maybe we would be able to implement all the laws that have been enacted by Parliament without looking for shortcuts, right? So my view is implementation is necessary rather than changes in the law. That's my belief.
A very quick response. And what Justice Mridul says is very true in the sense of there's a shortfall in the number of judges that we have. That shortfall isn't going away in a country of 1.5 billion people. So should we, for the next 100 years, just think in these terms? And which is where a lot of my suggestions actually with regard to this particular aspect goes to technology. Is that how can you use technology to very quickly take off the plates of judges, of human judges, put it in the realm of an algorithm? How can you deal with a whole host of cases that take 4 years, get them done in 4 to 6 weeks? Technology can do it. It's being used in various other parts of the world. No reason why it should not be capable of being used here. It is used, you can today fly aircraft without pilots. Delivering judgments is a lot easier.
But no part of the world, human judges have been replaced by technology.
So absolutely true. So absolutely true. Today, they have not been replaced. They can supplement. So if a judge can get a draft judgment out of an algorithm, look at it. If he wants to make changes, and then bless it one way or the other. It'll make his job so much more quicker. You'll be delivering so much faster. You'll also be more consistent because the same algorithm that works through the country. So there are ways that you use technology. We actually, when you work with law firms, a lot of law firms are using technology. If law firms can use technology to deliver consistent, high quality legal advice to clients, there's no reason why the same ideas can't be actually put to the state.
May I respond to that as well, very quickly? I can't but agree with my brother. But there is a difficulty. If judges were to get draft judgments, we would be prosecuted, first of all. I must point that out. We would be prosecuted. We are required to discharge our functions without being influenced by anybody in any manner. So we can't receive draft judgments. Whether we can use technology to become more efficient, to become more effective, yes, I believe we can. And live streaming of any proceedings, including proceedings in Parliament, with utmost respect to my friend in Parliament, has the effect of sobering down participants. So the minute you introduce live streaming, the judges are more reticent, which judges should be, and lawyers are more circumspect because they are unable then to carry things in appeal and say, I argued this before the High Court. So I'm all for technology. But judgment writing, I don't believe we've reached a stage where you can replace judges with artificial intelligence. And I'll tell you why. I'm not very good with technology, but I remember that eventually artificial intelligence does not have emotion. And correct me if I'm wrong. Right? So therefore, an interpretation for the spirit is willing, but the flesh is weak, would be the drink is good, but the meat is bad. So eventually, you can't do away with judges yet. We may reach that stage. And all strength to you, Anand. I hope we get to that stage. But at this stage, it is not possible to replace judges with artificial intelligence.
Thank you. You said live streaming makes everybody sober. What can happen due to judges? But I think live streaming, our experience shows, so far as Parliament is concerned, the members have become louder.
I was just going to say that, if I may just come in for a couple of things. That was exactly what I was going to say, sir, that my experience has been live streaming of Parliament has made it more theatric. Because now members are trying to have that 30 seconds or 1 minute of their piece, which will be becoming viral. That will be something that they'll be able to circulate on the WhatsApp groups. So it has definitely brought down the moderation of the speeches in the Parliament. And sir, I must tell you that I have now witnessed that this has started affecting in the courts also, because some of the matters, maybe not at the Supreme Court level, but in the High Court, where the lawyers know that these matters are going to be viewed by everyone. When the whole state is interested in a particular matter, and I was party to one such matter, There was one lawyer who was just playing to the gallery all the time, speaking in two languages so that it reaches the widest audience. While we couldn't get up and protest, we at least requested the judge that, look, we follow the English as a common medium, so let the arguments happen at least in one language so that we are able to follow it better. But on the main question, if I could just come in for a bit, because I have a slightly different view. I mean, I agree with the idea that technology should be used. I agree with Mr. Siddharth's suggestion that we need to have more judges. But having more judges, infrastructure is something that's going to happen in the longer run. I mean, someone will need to work towards it. I'm sure the government is wanting to bring more judges, but I feel we have to make do with what we have at the moment to deal with the crisis which is in present. So Justice Patnaik had mentioned how just with effective management they were able to deal with this caseload in Madhya Pradesh. Sir, I have been witness to one registrar, judicial registrar that we had in the state of Andhra Pradesh when I was a very young lawyer. The registry was in a mess, but this was a very efficient district judge who was posted as the High Court registrar. He just came, he undertook docket management, he went to the judges, explained to them that we can bunch matters like this, we can list matters like this. The pendency in the High Court came down by 25% in 2 years that he was a registrar. He then became a judge of the High Court, unfortunately. Fortunately for him, but unfortunately for the system, and it went back to normalcy. So, sir, my thought is, with the existing systems, there is a way where we may be able to run them a little better. We haven't brought in professional management to courts yet. We don't have any, because it all depends on the Chief Justice. The Chief Justice could be a good manager, he could be a terrible manager, he could be a great judge. The skill sets are very different. For a Chief Justice to run a state in the High Court and for a Chief Justice of India to run the country and administer the justice, it will need great management skills. And I've seen that some of the greatest judges are extremely poor with management skills. And there have been some very mediocre judges who have turned out to be brilliant Chief Justices because they are exceptional in management skills. So I really think the Chief Justice of any court, High Court, in the way our courts are functioning, he should have the assistance, because first, you're picked up because you're going to be a good judge for judging the cases. You're not picked up because you're a good manager. Now, rule of seniority ends up with maybe a brilliant judge becoming the Chief Justice, but he may be an absolutely poor manager. Now, where is the institutional support we have? Where is the collaboration with some business schools or management consultants that come in and provide that support to the Chief Justice, because that is providing support to the High Court at the High Court level and Supreme Court. Now, we don't have that. Now, this is something that could be done even without artificial intelligence coming in and the technology being able to amplify it. So, if we use our existing infrastructure, put in place certain systems. I think Anand in some part has touched upon this docket management. He's also mentioned about an international organization that is willing to lend arms to whoever wants to use that infrastructural ability and institutional ability to build that institution of managing the dockets well. So we may have to get down to this very fast, but the single biggest problem that I find is who has to get down to this. Our judges have been so guarded in protecting the institution, they don't let the executive come in there. They don't let anybody else come in. They're extremely guarded, and there have been complete failures in terms of doing this docket management with what we have. The infrastructure, the number of judges needs to increase, the courtrooms need to increase. So, but I think if something could be done on this to start with and use technology to aid, some small steps could take us a long way.
Well, you see, this court management system was tried in India. When I was Chief Justice in Madhya Pradesh, I know many places court managers were appointed, but did not work. Because the management people who came, all big management people, they could not understand the court system. They could not, they gave up. I know Mr. Mohan Gopal was there, we were trying, we put IMM people, this people, that people. They were appointed court managers throughout the country was appointed. Orissa High Court appointed number of court managers. Then when I inquire, after I retired, inquire where the court managers, they are all left, sir. Okay? They are found useless. They could not handle it. So, elephant. Unshackle the elephant is very difficult, even beyond the management. Another thing that he mentioned about, you can't allow people to write your judgments from outside. 100% right. One thing that can be done, which I suggested to Justice Kabir when he wrote judgment, why should he write what Mr. Reddy argued, what he argued, what that argued? Let that submission come to place straight away. Right? And so far as judge is concerned, on the issues, just keep on expressing opinion. That way judges work get this. If that is good drafted, what are the submissions? What are the issues? Both sides agree. Placed before the judge and he gives on delivered. And that's exactly what I do in arbitration now. I allow others to draft the draft the claim, statement of claim, of that pleadings. And then when it comes to point of dispute, after that I start. And it's working.
So that's the purpose of these written submissions, which I think all of us as lawyers hand over to the courts every day. There is yet another issue that must be addressed. It's not as if Indian courts, there is no technology available. And I can tell you this through personal experience. I went to Manipur and we had a fund, huge sums of money for virtual appearances, for online filing. And you'll be amazed to know that Manipur was going through a very difficult period. Lawyers and not even judges could attend court. So what we did was, within a short span of 6 months, we had systems in place where you could file pleadings before a judicial magistrate first class in a strife-torn area from anywhere in the world within 6 months. You could also appear through video conferencing before that judge from anywhere in the world. So it's not as if we lack systems. But the fact is that we are, and I think on this Justice Patnaik will agree with me, the amount of work that the workload of a judge on a regular basis completely negates whatever technology that you may apply. Short of replacing the judge with artificial intelligence, where we don't know, that may work, that may not work. But the fact is, short of doing that, if you need an individual with a certain amount of caliber and experience to apply themselves to the facts of a case, right, and come to a conclusion, then you must have people keeping in mind the tasks that need to be performed by the end of every working day. Short of that, all of these changes, court management, case management, we've been talking about this for the past 25 years. And I'm sorry to say that despite all our efforts, it doesn't seem to have worked. But the reason why we are discussing is because Anand was bold enough to address the elephant in the room. And it is important for all of us to express ourselves freely on the subject of the changes that need to be made in the legal system pronto, today. On that issue, I think we are all agreed. We are all agreed.
Yeah, please go ahead.
So, as the only economist in the room, perhaps, with maybe the exception of Seema.
This is the management man.
Yeah. So, let me weigh in on a couple of points. I think one, most people in this room will understand the intrinsic worth of justice and the intrinsic problem with not getting justice. Let me bring the economist's perspective to it. Older people in this room will remember what India was like before 1991 and what India has been like after 1991. Younger people, unfortunately, do not have this experience. But let me assure you that the country is a different place. Right? The country is a different place because we have been able to grow. And while our growth has been decent for the last 30 or so years, averaging anywhere between 5 to 7% on average, and that's already brought in a lot of change, we've only been able to achieve that because we started from a very, very low base indeed. We started from being one of the poorest countries in the world to being a slightly less poor country today. We are barely in the ranks of middle income countries. We are about, I think, 130th on per capita income out of 190 odd countries in the world. So there is a long, long way for India to go. A strong enforcement system for contracts forms the very basis of any growth whatsoever. There is no shortage of countries in the world that have grown fast for a few years and just stalled. So the sort of instrumental worth of justice is very, very large indeed. Adam Smith, back when he first wrote The Wealth of Nations, pointed out three things: peace, easy taxes, and the third was a tolerable administration of justice. And I think Anand has made a great point that we do not today in this country have a tolerable administration of justice. And I think you actually missed a beat in your chapter where you're saying India is today 60th in the ease of doing business rankings. If you dig a little deeper into those rankings, there is a contract enforcement sub-ranking in which India is 163rd. Yeah? So that's actually how dangerous this risk is. Sanjeev Sanyal recently said courts are India's biggest vulnerability when it comes to growth. So this is enormously important. When it comes to Anand's prescriptions, I disagree with a number of them, but I do agree with thrust on two very, very important pieces, which I think he and Justice Patnaik called them out. The number one, and I'm an economist, so I tend to think in terms of incentives. The number one is incentives. Whose incentive is it today to get justice done tolerably quickly? Is it in the lawyer's interest? It is not. Is it in the judge's interest? It is not. It is in the interest of both plaintiff and accuser if they are innocent, but not if they are accused, if they are innocent, but not if they are guilty. So there are very, very few actors in the system who are incentivized to make the system work. And to me, that immediately says a system like that is not going to work, and lo and behold, it does not work. And I think Anand is very much on point in saying, can we align the incentives of at least a few stakeholders? Can we reward lawyers on result, right? Can we make frivolous things cost more? So if you keep pushing costs, can the costs be rewarded to the loser? I think these will finally bring about some more incentives. So I think by far the ones that are most important and most consequential are these shifting of incentives within the system. I think they are critical, and if at all we do try and focus on some of these should be the ones. The other is the one I think that Anand talks about, which is culture. What is the culture in our legal system today? In the absence of incentives, culture is what gives you soft norms and soft incentives. And he rightly points out that the culture in courts is dysfunctional. It comes from 17th century England. I don't know. Before that, I don't know. So if we cannot change incentives, we must change culture. We are all equal citizens of a country that is aspiring to become great. We cannot have a culture that does not treat us so within a justice system. I'll stop there. Thank you.
Thank you. Thank you so much for joining us, sir.
Thank you, sir.
Yeah, sir. A group picture.
Yes, yes. Thank you, sir. Several significant takeaways from this conversation. One being that judges don't need to be as worried about AI taking away their jobs as other professions around the world probably. We're opening the stage to audience questions. Please raise your hands and we'll get the mic passed on there. Yes.
And while we pass on the mic, I can be provocative by saying that I actually believe the opposite. Judges should start getting worried about AI taking their jobs because it's coming faster than we know it. Sir, please go ahead.
Okay, so my name is Captain Sanjay Gehlot. I'm a veteran and retired IRS officer and also cartoonist for the book. Okay, so my question is the sociological big question, parochialization of the process of modernization. So we have modern institutions and in conflict with the old values like patriarchy, misogyny, caste prejudices, and a whole lot of things. So is legal reforms possible without cultural reforms? That's a big question. That's my question.
Anand, I think you're best placed to.
So let me take a go at it. So very good question is legal reform possible without cultural reform? When we think of culture, it's not one single culture that exists in our country. There are multiple cultures that exist in our country. We can, however, have one law. And if that one law is equally and effectively implemented, it will bring about a change in culture because as human beings, we respond to the strictness of rule. It will drive a change in behavior. If our implementation is going to be weak, people are going to go the way they would like to because there's freedom to do what they will. So that freedom needs to sort of be permitted within the realm of law, and therefore, once law begins to get implemented in a clear fashion, in a transparent fashion, in a fashion that does not discriminate, we will find a change in culture. At least that's what I believe would happen.
If I may just add a thing. Most times, laws are made for the purpose of changing behavior or for controlling behavior. That will breed a change of culture. So if you need the laws to be implemented well, if we have good legal reforms that will ensure that those laws are implemented better, the legal reforms could actually lead to a cultural reform also. It's not necessary that it has to precede. On the AI questions, couple of things were discussed. I don't know if people in the room would know, but I think it might be of interest for everyone to know that in Estonia country, that's the first country that's actually using AI for the purpose of trying some low-grade offenses, but all those judgments that will be rendered by the AI are subject to human supervision. That's the first use case where in the world people have started using AI for the purpose of determining certain small disputes. I think China has built up a huge database of how they would want to go about it. Again, for cases that are not political in nature, they're very specific. I think they are going to come up with something, but I agree that yes, I think that we are going to see some change that's going to be happening, and that seems imminent.
So just in terms of AI, if I just follow through with that thought with Anand, is that when we think of disputes, we think in terms of the most complicated ones and why a software can't deal with it. But if you look at what we have in our law, they are just a very large volume of very, very simple cases. Similar cases have been going on for 100 years. So sale of goods, landlord-tenant, almost every possible variation is played out, employer-employee. Lots of traffic offenses. Lots of cases that you find in the consumer courts. They are all sort of very similar. There is no reason why you can't actually have, and AI is a much abused term, but think in terms of a software or a technology. that you use in a particular fashion, it will be able to speeden up the entire justice process fairly quickly. Thanks. That was just my 2 seconds.
So, just chipping in, but this is one of my disagreements. I think technology is fantastic to make a functioning system function better, right? That's why technology actually comes into use. Technology cannot make a broken system start functioning. And I think our justice system is broken for all the reasons that Anand also gets into. It's nobody's incentive to get it fixed. You can have an AI system, and I actually think AI is very much there in terms of being better than the average judge for sure. It may not be better than the best judges, but if you've used today's AI, you know how good it is. So it's not that the technology is not good enough. It's the system that will use the technology will not use it to deliver things for the same reason it's not delivering justice today, and that is all the incentives are broken.
Rahul, just one quick point of distinction. I agree with you that enforcement of contracts, incentivizing, disincentivizing, that system needs some structural reform. But many of the disputes that are pending in court are not those that call out for structural reforms. So, in relation to those systems that are not necessarily broken or that are required to be improved, I think we could look at technology. I'm not advocating that we start using AI at this point of time, but whatever way we'll be able to use technology better.
Yeah. So I have a question. Actually, I'm supporting, right? That's why recently Supreme Court has suggested that paralegal volunteers should be included to help justice in POXO cases. POXO is very complicated and delicate. And there you are using paralegal volunteers who are not even well defined yet. That is bigger risk for these children in the life. Rather, AI could have better options for softer cases like traffic challans and all. So I would go for the AI option than to have paralegal volunteers introduced into the POXO cases. This is my suggestion and real protest also, kind of. And I need your input on it.
Is it okay if we club a few questions, 2, 3 maybe, and then we'll take them all together?
Please introduce yourself
Sure.
also.
I'm Suman Batra. I just wanted to make a couple of comments. Having worked with the government and outside with the IFC and the World Bank on the ease of doing business ranking, and now in this new avatar, the business ready, I agree that this one single most frustration has been the ranking on the ease of the enforcement of contract. We continue to remain below 150. And that is what is vented out by people like Sanjeev when they speak out. And of course, there's a lot of pushback when he does speak out very candidly in the way it is. But I wanted to make one more point, I think, which also is equally important alongside all the comments, Anand, you have made in your book. And of course, I look forward to reading it, is the access to justice, which is one very important aspect. And I'll mention it from 2 points of views. One is the tangible and one is the intangible. The tangible is the cost of accessing court. It's a big deterrent. It's not just the cost of distance, the physical distance, the geographical distance. It's hiring lawyers, is the payment of court fees, is the whole infrastructure added to accessing court, which makes it almost impossible for an ordinary person to fight litigation the way he or she deserves to. And something needs to be done. It involves probably a lot of self-regulation and introspection by lawyers who probably are the part of this infrastructure which create that kind of a dissuading effect. The second is the intangible, and that worries me the most. And one of the reasons why I say, because I have this conversation with my son, who is now 23, but I've had this over the last 4 to 5 years. Because most of us in this room belong to an era which have seen pre-91 and post-91. But 60% of this population today is India's population below 30. We need to hear them. We can't talk of reforms for them without hearing them, because they're the ones who are going to be impacted and they're going to use it. And they are the ones who will be left to implement it, if at all we make changes also. But without hearing them, I don't think it's really going to make a difference. We all know that the parliament doesn't really debate laws as they were meant to while making the laws. But I wanted to make a point from the accessibility point of view. The question that my son asked me is that his single is that does a lawyer, when he becomes a judge, becomes a superior person in the society? Or is it just an added responsibility? His question comes from the fact that why do they need to sit in such imposing buildings, which itself makes it inaccessible? That you need to stand up in queues. Lawyers have access, yes, they ought to have, but an ordinary citizen finds it very difficult to be able to cross into the doors where they need to get justice. This is a very important question which the young will ask. We are used to it, we don't ask these questions, but they find it very difficult. They also ask, why do they need to live in 5-acre, 4-acre bungalows in the Lieutenant's Delhi? Why do they need to be driven around? Why can't they drive their own cars like we do? We also contribute to society, we also do in our own way, to economy, why do they get this entitlement? Now these are very important questions, very difficult to answer. And why they probably ask is with the half understanding. Because some of our friends who are judges in different jurisdictions, they drive their own cars, they don't have drivers, they don't have special nameplates. In upper place of the car, they don't have security, they don't have anything. They live like ordinary people in the neighborhood. Their neighbor could be someone who's just anybody else in the society. And this whole exclusion from the ordinary is something which worries them. Because that is cutting the access to justice. Because telling them, oh, there is an iron wall around them. This whole concept, and you made about the perception of independence. That perception is very subjective. And I think we need to break that. Well, in Singapore, you can't compare it with Singapore and US because the judges are paid very well. They can provide for themselves. The state here compensates them so I just wanted to make that point, that access to justice is also something that we need to address.
Thank you. And if I can just request everyone in the audience to make sure that you have a specific question addressed ideally to one or the other panelists. And if you could please make it brief so we can take everyone. Yes, please.
My name is Rajiv Shatrat. I'm an engineer who got into entrepreneurship, which I have now closed down, after COVID. So, in my experience of this thing, running an organization in the country, I've come to the understanding that the state is the biggest litigant. This is a fact. Now, when the state is the biggest litigant, there are certain officials who basically follow that process through. And often what I've seen is the officials follow that process through for the sake of not paying, for the sake of the state not paying money to the other party. And the officials are never penalized, even when they are proven wrong. There is no clawback mechanism in India to say that you have willfully pursued a wrong case, the state has willfully pursued a wrong case and eventually lost and wasted a lot of money and time of the person who's being prosecuted, and there is no payback for that. So isn't that a reform which should be done? Number one. Number two, can't there be two parallel systems? One for the state cases, the state governments or the central government cases, one for the other cases.
So that is the elephant in the room. That is the elephant in the room. I must tell you that 60% of all litigation has the state or its instrumentalities as a party. Now what needs to be institutionalized is that when a constitutional court comes to a conclusion that a particular officer of the executive has deliberately delayed the conclusion of a case, right, for collateral reasons, we have recovered costs from them, from their salaries, from their emoluments. But you must understand that unless this is institutionalized and becomes a part of executive lore, it is not going to be possible for each such individual to be penalized for the delay he has caused in the just settlement of a claim. That is the elephant in the room. So, which is why Anand has done a wonderful job of focusing on the question of legal reforms. But this is something which he has done to engender the kind of discussion and debate that has begun today. When Anand sent me a copy of the book and I haven't read it in its entirety, I have been a little skippy. That's what senior advocates do. Right. But the fact is that the salient features, all of them need to be addressed. I may not agree with him on the recommendations that he makes to make these changes, but some of them, including what you've just asked, is very relevant, and this is an issue that has been flagged repeatedly and it must be addressed.
Anand mentions it in his book as well.
Great, that's wonderful.
So a bunch of these things I do address
Wonderful,
in the book. And just in terms of access and how technology is to be used.
So when you ask yourself that question, you must also have an answer.
Yes.
Okay, we're going to take last two questions. Okay, 3, and that's
So
it because
just
we have to
if I
wrap
can
it
just sort of jump in and respond to Sumant and Archana
Please,
very quickly.
please.
So access. One, the book gets into how the judges must move from sovereign authorities or deliverers of sovereign power to being service providers and what all goes in that process. The other is a lot of it is use of technology. When you can see, just going to a new courtroom is intimidating even for somebody like me, who's been a lawyer for a very long time. Every courtroom experience is intimidating. Let's be clear, because there are a host of lawyers that jump at you saying, "Merko hire kar lo." Yes, and he's been a chief justice of a high court. So the truth is, what is it that we can do better? And what we can do better is if your study can become your courtroom. So if you can connect through technology, you can, and it is how you use, and as Justice Mridul said, they are already, during COVID times, we have had online courts, etc. What can you do just in terms of improving the technology? I've appeared in international European courts sitting in Delhi. It's outstanding as an experience. The online courtroom experience is terrible in India. What is it that we can do? With very little money, you can change that. So therefore, when access becomes less intimidating, your drawing room can't be very intimidating, or your study can't be very intimidating. That will now then allow you access. It doesn't matter where the judges are sitting. Where can you get to justice system from is what will be relevant. And to Archana's point, it is, when you say use technology, it's not use technology and paint the entire wall with the same brush. Some kinds of technology better suited for some situations, so there has to be an intelligent use of technology. And you don't sort of start dealing with everything with the same brush. Sorry.
Great. Yeah, please go ahead, and
Yeah.
then we'll take 3 questions here.
Good evening. My name is Vimal, and I am a person who is interested in law. So, what I could understand from this august audience is that something is very wrong at the top. So, so if something is very wrong at the top, it must be very wrong at the bottom also, because that is where things originate. So, when I look at the criminal justice system in India, the cases are registered by the police officers who are trained in physical activities and also in investigation, but they may not be having a big understanding of the law. So my question is, will it matter if the case investigation and case registration, FIR registration, is separated? Because a person, the investigation agencies investigates and the independent justice department files the case. Because I think this may be easier, because even if a Supreme Court judgment makes it mandatory for the case registration to be made by the prosecutor after evaluation of the investigation. So that is my question. If it is probable, if it is feasible, can it be implemented?
Yeah, I think we'll have a bunch of questions. Yes, the lady there, and then gentleman. Can we pass on the mic? Thank you.
My question is not really related to his question, and I run the risk of having a disagreement with the best jurists in India, but I'll say it nevertheless. When we blame judicial delays on the population to judge ratio, aren't we using an incorrect metrics? Because When we say doctor to population ratio, that makes sense. Every person on the planet needs a doctor, but not necessarily a judge. The new litigations per 1,000 people is a better metrics. And to compare, Germany has 123 new litigations per 1,000 people. US has 74. India, best estimates, we don't have good data, but it's about 20. So in that sense, the new number of litigations per 1,000 people, the judge to population metrics does not hold water for judicial delays. Are we hiding behind something?
Great question. Yeah, we'll take one more and then open it up to the panelists. Yeah.
Hi, I'm Siddharth. I'm the person this book is trying to help. I'm the common man who spent enough time in the courts trying to seek justice on various things. And I think that if you add up everything that Anand has said in his book, we get to a point where we say, look, his ideas may sound utopian, and we're trying to get to Ram Rajya and beyond that. But if you take each idea for itself, my question to the panelists, the esteemed panelists, is, which of these ideas do you believe we can really implement? For instance, recording of proceedings, at least for these stakeholders, should be fairly easy, even if it's not for a live broadcast to the entire world. That should be fairly easy, and that keeps everybody honest. At least that tells me what happened in the courtroom, because otherwise I'm just relying purely on somebody's sort of description of it later on. Digital courts, for example, the country is so big and so massive. You could actually create in various places these little courtrooms, or which have technology installed, where you can go instead of going to a particular court in a particular city, and so on and so forth. So each of these ideas, if you were to implement them, I'm sure it will improve the system by a few percentage points. So which of these ideas do you believe is practically implementable? And in what time frame can we see that?
Can we take these three? Yes. I'll go in the sequence. To the first question, see, there has been a debate about trying to separate the law and order part of police from the investigation part of police. What you're saying is, if the investigation FIR needs to be registered by someone and investigation can be taken over by somebody else, FIR is just a starting point, and that's a starting point of investigation. The law we have already requires the public prosecutor to act as an independent person, and he has to be satisfied before he signs off on presenting the petition before the court. But that is not happening in India. So just having a system saying that there will be a different department won't be sufficient, because if both departments are going to end up speaking to the same executive, just like the public prosecutor is now doing it, though he's an independent lawyer appointed under a different mechanism, he's not discharging duties largely in that objective sense. So that may not be an answer by itself. To the second question, I agree that the new cases to the judges ratio may be appropriate, but then it's end of the day the same thing, because if you are doing that metrics, you are still saying 20 new cases in India per 1,000 people. So you are still going back to 1.5 billion people. So the ratio, even if you put it per cases, that may be a better metrics, I agree. But end of the day, it relates back to the population, because even the metrics you suggested are relating it to the population, because it's about 20 cases per 1,000 people. So Germany may have more, so they may need more judges per 1,000 people. But India will need more judges because India has many more people. Then to the third question, what immediately impressed me amongst the reforms that were suggested, I think there are two things. One is, most of the civil litigation in India, one party stands to benefit. Why do litigation stretch in India? Because one party stands to benefit by delay, and it has no cost to pay. There are no consequences. So the part that appealed to me the most with regard to what is most practical is, make it deterrent for a mischievous litigant to continue litigating by having some standards of burden that can be imposed on him. Like if it's an interest, if it's delaying the payment of money, the interest should be more than what he pays in the market. We have that in MSME today. People are scared because the interest rates are 36% compounded, that can be compounded quarterly. And you also mentioned about this live streaming and broadcasting. I am someone who is a strong advocate of that. In fact, there's one of my colleagues here who briefed me in a matter in Supreme Court. When a particular case was being tried, the accused in that particular case informed the court on the date the matter came up. The matter was filed on first day, matter came up before the High Court on 8th day. On the 8th day when the matter came up, in between, on the 6th day, some charge sheet was filed. So 8th day when the matter came up in court, in the oral argument, they brought it to the court's notice. There's a charge sheet that is filed and maybe someone please grant a stay. But the judge in the order did not record it. He did not record it, and then the allegations that were made when matters came to Supreme Court was when they filed the case, they did not mention about the charge sheet. Now, only because that court hearing continued to be there on YouTube, we were able to do a transcript. We were able to produce before the court to show, look, on the 8th day, the lawyer actually argued that this charge sheet was filed, though it is not recorded. And I've seen this happen with judges also who have been mischievous in deliberately omitting some arguments. So when we go up in appeal, it becomes a problem. So any telecast is always, sunlight is the best disinfectant. I am someone who strongly advocates for that.
No, incidentally, he didn't tell you that court proceedings for the better part are today being recorded.
Yes.
So that is the one thing that we needn't fret any further. They are all being recorded. Therefore, it becomes a part of the pleadings before a superior court. That's being done.
I don't think we're taking more, but we have other questions to be answered. Have you addressed everything? Mostly, yeah. So, I think we can continue the discussion over dinner. Does that work?
I think we can informally continue to brainstorm and discuss as we proceed for drinks and dinner. I'd like to thank the panel for such an engaging discussion. And I hope we all take a lot of thoughts and reflections back as we head for our Monday and the week ahead. I'd like to now invite Arjun to share the closing note and a vote of thanks.
Thank you. I'll keep it short so that we can all head for dinner. But thank you everybody for being here from your busy schedule. Coming here, I think Anand in classic style, how he has practiced law, is also tried to write this book, starting with simple solutions and then getting into the more meaty, interesting ones, which I'm sure we'd love to discuss after this. Some of them that sort of have come over many of our lunch conversations over the years are some of the more controversial ones, so to speak. Why should government officers not be responsible for things that they create mischievously or even unwittingly? Why should we not embolden the arm of the executive in deciding who our judges should be? And why should we not make incentives clearer for judges to be independent, like making their tenures longer? I think it's taken a long time in many iterations for this to come. So congratulations, Anand. And look forward to speaking to many old friends and ex-colleagues over dinner and drinks right after. Thank you.